Good evening, everyone, and welcome. I'm Karen Bravo, Dean of the IU Robert H. McKinney School of Law, and it is my great pleasure to welcome you to the Alan and Linda Cohen Family Foundation Sports and Entertainment Law virtual lecture. The many sports-related entities located in Indianapolis, including the NCAA headquarters, literally across the street from our building, make sports law a very attractive and fertile field for our students and graduates. We welcome and organize this lecture as a way to contribute to the knowledge and expertise in this important area of law. This event is made possible through a fund established in 2011 by Alan H. Cohen, a member of the McKinney Law Class of 1973, and Linda M. Cohen, together with their daughter, Lauren Cohen Edmondson, a 2005 graduate of our law school. The members of the Cohen family have been great friends of IU McKinney, donating their time, talent, and treasure to our cause. We're extremely grateful to them for making this educational opportunity possible. A special welcome to Lauren Cohen Edmondson, who's joining us this evening. I would also like to thank Assistant Dean for Diversity and Inclusion, Patricia Kinney, for organizing this panel, and our External Affairs Office for providing such excellent support. For this year's very timely topic, the changing landscape of college athletics, we're very happy and proud to welcome a panel of experts from all sides of the collegiate sports world to address the legal aspects in particular of this subject. We appreciate all of you for giving your time to us today. Guiding us through the event will be our moderator, Julie Lach, a 2004 graduate of our school who serves as commissioner of the Horizon League. Julie is very knowledgeable and highly influential in the arena of sports law and college athletics, and also serves as a member of our law school's Board of Visitors. It is my great pleasure to hand over the virtual podium to Julie to welcome our panelists. Thank you to each of you for contributing your knowledge, experience, and time to this very wonderful panel.
Dean Bravo, thank you so much. It is good to be with all of you this evening. And again, thank you to our panelists for agreeing to join us. I'm going to introduce the panelists, but before doing so, I wanted to just go over a few housekeeping items. First of all, just to note, if you'd like to obtain CLE credit, then it is important that we're able to monitor your participation and engagement throughout the session. So in order to earn that credit, you'll need to make sure that you are tuned in via your computer or the Zoom app on your smartphone. And as part of that monitoring of engagement, there will be 3 polls administered throughout the hour. So please pay attention, and when those pop up, just answer the question, and then the notice will leave your screen. If you've got any questions on CLE credit, you can contact Elizabeth Allington at the email address listed there on the screen. And just in terms of the order of events here, each presenter will speak first after I go through introductions. And then we have reserved time at the end because we know you'll likely have some good questions for them given the topics they'll be covering. So we'll be sure to allow approximately 15 to 20 minutes toward the end for Q&A. And if you do have questions, we would ask that you simply type those into the Q&A tab on your screen. And then we'll be pulling questions or themes from those in order to share with the panelists. So now moving on to the introductions of our panelists. I'm going to start with Professor Gabe Feldman. Gabe is the Sher Garner Professor of Sports Law and the Paul and Abram Barron Professor of Law at Tulane Law School. He's also the director of Tulane Sports Law Program and the co-director of the Tulane Center for Sport. Prior to his transition to higher ed, Gabe was a litigator with a firm in Washington, D.C., where he practiced a variety of areas, many of which he'll be talking about today. And his academic accomplishments and published articles are too long to list here, but I will note that he is clearly an expert in the sports law field, and we are really grateful to have him with us. He's often quoted in national publications, and he serves currently and has for some time as an on-air legal analyst for the NFL Network. He also serves on many national boards, including the Board of Directors for the Sports Lawyer Association. So Gabe, thank you. He will be talking about the implications of the Alston versus NCAA case, legal implications, and what that means as we look towards the future. So we're glad to have Gabe with us. Our second panelist will be Gloria Nevarez, who is a friend and colleague of mine, commissioner of the West Coast Conference. Gloria is always a trendsetter. She joined the West Coast Conference in April of 2018, but has been in the collegiate sports ranks for many years. Prior to that, serving both on campus and in conference roles. She also is a leader across the country on many issues, including diversity, equity, and inclusion. And the West Coast Conference adopted the Russell Rule to promote diversity in hiring under her leadership in 2020. Gloria also serves on not just NCAA committees that she'll be talking about today regarding the NCAA constitutional overhaul and the NCAA transformation committee that really has tied into much of the change happening nationally. But she also is a member of the Men's Basketball Oversight Committee and the Knight Commission. So we're really excited to have Gloria join us today. And then finally, we'll be hearing the campus perspective on some very important name, image, and likeness issues that are facing the collegiate athletics enterprise from our another alum of McKinney, Tom Mitchell. Tom is the Associate Athletics Director for Compliance at Purdue. He's been there since 2010. Prior to Purdue, he had stints at Ohio State and at the University of Southern California, as well as the NCAA. Tom is also a leader in his industry and has served for many years on the National Association for Athletics Compliance, which is really the leadership go-to organization for compliance standards across college sports. So we are extremely excited for the expertise and knowledge of our panel. And without further ado, I will now turn to Professor Feldman to begin.
Thank you, Julie. Thank you for the introduction, and thank you for the invitation to participate in this panel. I'm honored to be alongside my fellow panelists, and there is a lot to talk about, so let me jump right in. And as Julie said, I'm going to be covering the Alston litigation and what it means. And it's really hard to talk about the Alston litigation without talking about everything else that's going on in college athletics. But just to kind of give you the overview, and then Gloria and Thomas will talk more in specifics about these other areas. But in addition to the antitrust threat that we're seeing in the courts, we're also seeing obviously activity at the state level with name, image, and likeness. We're seeing at the federal level with potential legislation. We're seeing it with the National Labor Relations Board and the General Counsel's recent memo concluding that college athletes, or at least college football players, are employees. And we're also seeing it in the federal courts for the Fair Labor Standards Act litigation, where the NCAA just had a motion to dismiss denied, where a judge suggested that under the FLSA, college athletes might be employees. And we have the Constitutional Convention ongoing. So other than that, there's nothing going on in college athletics. So let me talk about Alston and what the court said and what it means and why we should care as people involved in college athletics. The background in the case is that a group of what was styled as a class action of FBS football players, men's and women's basketball players, challenged the restrictions that the NCAA has in place on athlete compensation. And there were really two categories of restrictions that were specifically at issue. One were benefits unrelated to education. So that would be what you would consider pay for play or potentially even pay for name, image, and likeness. And the other was education-related benefits. And those would be musical instruments, science equipment, laptops, postgraduate scholarships, things, as the title suggests, related to education. And the district court, Judge Wilkin, who was the same judge who had decided the O'Bannon case and is the same judge who is hearing the next antitrust case against the NCAA, decided in favor of both the NCAA and in favor of the plaintiffs. And what Judge Wilkin ruled was that the NCAA under antitrust law is entitled to maintain its restrictions on benefits unrelated to education. Because what the NCAA is trying to do and has been trying to do for decades is maintain a line of demarcation between college and pro sports. They are trying to produce a product that is different than professional sports. And what makes it different in large part is the fact that these are students and that they are not paid based on their athletic ability. They are not paid to play. They're not paid, again, for their name, image, and likeness. So the NCAA had the right under antitrust law to continue restricting those benefits unrelated to education so that we could have a difference between college and pro sports, because if college athletes were paid unrelated to their education, all of a sudden they look just like professional sports, professional athletes, and that would be not only harmful for college sports, but also for college athletes and for the consumers, because they would lose something that they enjoy, which is this product distinct from pro sports. But Judge Wilkins said the benefits related to education, again, those computers, the musical instruments, the science equipment, there was no justification for the NCAA to restrict those benefits. Because if the NCAA's goal was to separate college sports from pro sports, to separate the pros from the students, there was no reason to restrict benefits related to education, because after all, that's what we're trying to do, is educate the students. So there was no, as we'd call under antitrust law, pro-competitive benefit or rationale for restricting those benefits related to education. And there were two categories of benefits related to education. One were the in-kind compensation or benefits. So again, that was the musical instruments, the stuff that's not cash. There could be no restrictions on those benefits from the NCAA. The other was cash compensation related to education, and that would include awards for academic achievement. And the court said they're not allowed to, the NCAA, restrict that cash benefits related to education at an amount lower than its aggregate limit on parallel athletic awards, which, to synthesize all that, basically means athletes can get some cash benefits or cash related benefits for athletic participation, for achievements in bowl games, for making bowls. And the court said, if you're already giving them that money, what's the difference if you also give them that amount in cash related to education? So that number that the court identified was $5,980 per year. So Judge Wilkins said that the NCAA can restrict cash benefits related to education, but it can't be at an amount lower than $5,980. So what that meant was, after the district court decision, the NCAA could continue to limit the benefits unrelated to education, but could not limit the benefits related to education. That went up to appeal in the Ninth Circuit. The Ninth Circuit affirmed. And then we had this very big moment that the NCAA and the plaintiffs had a decision. Do they appeal that to the Supreme Court, or do they just let it rest? They just let that be the decision. The plaintiffs decided not to appeal to the Supreme Court. They could have challenged the ruling that the restrictions on benefits unrelated to education were illegal under antitrust law. They chose not to, perhaps for a variety of different reasons. But the NCAA did appeal the finding against them. So they did appeal the conclusion that the restriction on benefits related to education were illegal. So that was the only issue the Supreme Court was asked to decide, whether the NCAA was allowed under antitrust law to restrict benefits related to education. So to use a football analogy, or to use a basketball, whatever analogy you want to use, the NCAA had really, they'd kicked a field goal maybe by having a split decision in the lower courts. And then they went and took the field goal off the board and went for the touchdown. They asked the Supreme Court to say, not only can we restrict the benefits unrelated to education, but we should also be allowed to restrict benefits related to education. And even more broadly than that, they asked the Supreme Court to give them not necessarily full immunity under antitrust law, but significant deference under antitrust law. So they didn't have to keep returning to the courts to defend their rules. Because what's unique about the NCAA as compared to most other industries is the schools that make up the NCAA, although they compete on the field, but they also cooperate off of the field, because you cannot have a college football game unless the two teams agree on where they're going to play, when they're going to play, what rules they're going to play. So everything the NCAA does is an agreement between competitors. And under antitrust law, any agreement between competitors is subject to attack under Section 1 of the Sherman Act. And the NCAA said, Supreme Court, this is no way for us to do business, that every time we reach an agreement that we think is necessary to create our product, to provide these benefits to college athletes, to have broad-based athletic opportunities, right? To provide a product that our fans want. Every time we reach an agreement, we get sued under antitrust law. So Supreme Court, you should come in and say you're entitled to special protection. And that special protection had been given to the NCAA by the Supreme Court in the 1980s in a case called NCAA versus Board of Regents. Ironically, the NCAA lost that case, but in the decision, Justice Stevens said, although they lost this case, the NCAA clearly is allowed to do a lot of things to protect and create college sports. Among those things are to place restrictions on the compensation that college athletes receive. And that language had been used by the NCAA in dozens of antitrust cases to protect their restrictions on athlete compensation. So now we go back to the Alston case, and the NCAA says, look, you should affirm that language and actually strengthen that language, because there was some question about whether that language was actually binding on courts or whether it was dicta. And this is a little bit of a be careful what you wish for, and hindsight is 2020, but in a 9-0 decision, the Supreme Court upheld Judge Wilkins' injunction and said that the NCAA's restrictions on education-related benefits were illegal under antitrust law. Not only that, the Supreme Court said that the NCAA is not entitled to deference under antitrust law, that the NCAA has to defend its rules, its restrictions, just like any other defendants do in any other industry. So the key points that come out of Alston, one is that the benefits unrelated to education, those can still be restricted by the NCAA. Benefits related to education cannot be restricted by the NCAA, but conferences and institutions, okay, not the NCAA, but individual conferences and institutions can impose restrictions on benefits related to education. So the Mountain West, the SEC, the ACC, they can decide if they want to really put any restrictions they want on athlete compensation. What they can't do is agree with each other. And what they can't do is agree as a national association to restrict those benefits. What we've seen in practice already from the SEC and at least one other conference is they are not going to place additional restrictions on benefits related to education. They've already announced that they're going to leave it up to the individual schools to make that decision. So we're going to start seeing more and more conferences announce what their policies are, more and more schools announce what their policies are. But the last point, and I think why people in college sports are so concerned about the Alston decision, because if you just look at what I just articulated, there's really not changing very much. All it's saying is that the line of demarcation between college and pro is still whether you are paid benefits related to education, right, which is permitted, or benefits unrelated to education, which is not permitted, because that would make you a pro athlete. Alston just said you just have to broaden the definition of education-related benefits a little bit. What it didn't say is that this is the destruction or the end of the collegiate model. What this didn't say is you can now pay the athletes whatever you want. They weren't asked to decide that. So there really wasn't a monumental shift from the 9-0 decision from what we have now, from what we had in the past. But where the fear comes from is Justice Kavanaugh's concurring opinion. Justice Kavanaugh's concurring opinion, and the one that sends shivers down the spine of everybody in college athletics, said that the NCAA's business model would be flatly illegal in almost any other industry in America. And what the NCAA calls amateurism, or calls its collegiate model, where they define their product in part based on the fact that the athletes are not paid to play, Justice Kavanaugh calls price fixing, illegal price fixing of labor, and foreshadowed or previewed that if he had the opportunity to rule on the other restrictions on athlete compensation, these restrictions that are unrelated to education, he would likely hold them to be illegal. So the bad news for the NCAA is that if Justice Kavanaugh has his way, then many of the rules as we know them today, the compensation restrictions on college athletes, would be held illegal. The good news for the NCAA is that Justice Kavanaugh is only one justice. And as harsh as his concurring opinion was, it was just the opinion of one justice. None of the other justices signed on. Now, there may be reasons why they didn't sign on, but for now, the law is still that college athletes under antitrust law cannot be paid for play. They cannot be given compensation unrelated to education. But what we're seeing is not only the Supreme Court giving less deference to the NCAA, we're seeing state legislatures giving less deference to the NCAA. We're seeing the National Labor Relations Board give less deference to the NCAA. We're seeing federal judges in the Fair Labor Standards Act giving less deference to the NCAA. If that trend continues, it's only a matter of time before the rules are chipped away at and maybe broken completely. And there is a case in the pipeline right now called the House and Prince case, where those plaintiffs are claiming that any restrictions on NIL compensation are illegal under antitrust law. If they are successful, the next step may be challenging the pay for play restrictions. So we are at a point in time right now where if we continue on this trajectory, where people or outside entities are not given deference to college sports, then college sports will fundamentally change as we know it. I have some thoughts on how we could try to change that trajectory to stop it, but I will stop now and pass it back over to Julie, because I know we have a lot of other things to talk about.
Gabe, thank you. That was terrific in terms of setting the stage from the federal intervention, the change that has come about for college sports externally. We have invited Commissioner Gloria Nevarez to join us to talk about what is the NCAA doing at this critical point in history from trying to build change from the inside out, if you will. So there has been multiple efforts underway, and Gloria has been a part of those from the inside with her service on those two NCAA committees that I noted. So Gloria, I'll turn it over to you. Thank you.
Thank you, Julie. And I should have raised an issue in our practice session. Never want to follow Gabe. You do such a great job of breaking down all the complex legal environment. And I just really appreciate listening to you take all these concepts and the timeline and break it down into digestible information. So within the NCAA structure, those of us that are trudging along, trying to put on live sports post-COVID, this is one of many things that has been going on in the environment. Most of you remember the women's Final Four was brought to light as not being equitable with the men's event. And so the associations, the national office has been undergoing a gender equity review. There's also a set of bylaws that went into effect regarding transfers of student athletes and allowing men's basketball, women's basketball, football, and baseball players to transfer and compete immediately. And that hadn't been the case previously. In addition, we had COVID-19 and have a class of what we're calling super seniors and basically a double up on the freshman class for those sophomores who really didn't get to experience that on campus and have gained an extra year of eligibility. So we have a lot going on. And amidst all of this and following the Alston case, President Mark Emmert and the board decided, we as an association need to redraft our constitution. And the two articulated goals were, one, we need a fleeter and more able system to react to current events and to pass rules. You all heard of the big old bureaucracy that the NCAA is and how come they can't ever pass rules and all that. Well, this effort to revise the Constitution is to get at that and get us more fleet. The second articulated goal in this press release was to allow more autonomy at either the conference or the school level. And on one hand, you could surmise that part of that was mimicking some language from the Alston decision that Gabe talked about, but also the power dynamics within our structure and allowing, right now we have a group of conferences, the Power Five, that do have some autonomy in the system to make their own rules and to potentially expand that. So those that are investing the most, aren't maybe under the same restrictions of those who can't afford to invest the most. Anyway, that's just my hypothesis about what's behind the autonomy. But what we know today is that those two articulated goals were the ones out there in the press release by the board and President Emmert. So this release promised transformational change, and we got a group of people together. Myself, Robin Harris of the Ivy League, and Jim Phillips are the three Division I commissioner representatives in the room, and we're selected to represent each of our subdivisions. Jim is the BCS group. Robin at the Ivy is the what we call the FCS football championship subdivision. And then I represent those schools in what we lovingly refer to as BC 10, basketball centric 10, those leagues that don't sponsor football in either the FBS or FCS system. So as we get into the process, just yesterday, November 15th, time is a-flying, we held a webinar to unveil the work of phase one. Well, just a quick note on phase one. As we finished phase one, it became very apparent that the change we were making is to the high level structure of the Constitution. And the public and the media and those casual observers are expecting transformational change. But we all knew the change that happened in phase one was more policy and constitutional realignment in order to enable the transformational change. That how are you going to solve enforcement? How are you going to solve name, image, likeness? What are you going to do with the transfer, et cetera, et cetera, et cetera? All those things that are making headlines are going to be pushed to each division to solve in what is now phase two, which begins today and is called the transformational phase, to kind of guide the public into understanding that that's where the rubber's really going to hit the road. So for the purpose of name, image, likeness, all of that lived at the top of a constitution that governed all three divisions, Division I, Division II, Division III. And for those of you who aren't aware, Division II and Division III have the vast majority of members in our association. And when voting in block can rule the day on pretty much any issue. So given the new issues of today's landscape, and given that a large majority of these are very specific to Division I, it made sense to decouple some of these things and allow each division to react more fleetly and with more autonomy to these issues that are coming up, both legal, governing, and just, health and safety is another one of the day. So that's what you'll see in this new phase one of the Constitution, was the decoupling of Division II and Division III and giving the authority to Division I to go forth and tackle the NCAA policy and legislation around these issues. So right now, we don't have a lot of detail of what that's going to look like. I know the Division I commissioners, led by Julie Lach, have been working on a parallel process to kind of keep up with it and figure out what happens to all of this. One key tactical question has been, okay, we took a big constitution of 40 pages, dropped it down to 20 and pushed a lot of stuff to the divisions. What's happening to all that stuff that came out of the phase one? And the answer is it's going to live in a parking lot, which is probably going to look like a new sub-article of the Division I Constitution. So important takeaways, it's not inactive. It's still live legislation. Just because it didn't survive in phase one in the top level doesn't mean it's no longer active legislation. And in phase two, we'll decide where all that goes, what stays, what goes, and where it lives in the Division I Constitution. So that's just kind of a snapshot, mostly process, but where we are today, knowing that phase two will get a little more granular regarding those headlines that I think so many people are interested in figuring out. What are you going to do about those things? And I'll tell you right now, I don't have those answers today.
Gloria, terrific. Thank you. And I might just add, as for those that might not live in college sports, 2 items that are in that very important parking lot that is hopefully very close to the building is our championship access and revenue distribution. Just to name a couple of big ticket items, but those are critical to every conference, to every institution, especially when you talk about student athlete opportunities in that championship space. And then of course, the revenue distribution, how do you keep supporting these opportunities? So yes, much work remains. And Gloria, we're thankful that somehow you find time outside of your day job to serve on these NCAA committees. Thank you. And that's a good segue to, she mentioned several national issues that I think I had thought were in the rearview mirror, but they're not. The transfer piece, the COVID-19 and safety protocols we've all had to implement, the Kaplan review relative to ensuring gender equity. And then now we're going to hear about name, image, likeness, which really came to the forefront from a national perspective last summer, as we were all also managing COVID fallouts as well. Actually, this past summer, right, Tom? But nonetheless, then it triggered a lot of conference and institutional action, and Purdue has really been a leader in that space. And we welcome Tom to share with us how they have approached this new deregulation and how they've managed it at an institutional level. Thanks, Tom.
Thanks so much, Julie. And yeah, batting cleanup is not going to be easy for this panel, but I really do appreciate Gabe and Gloria setting the stage, because for everybody keeping score, federal and state laws, NLRB, NCAA guidance and rules, constitutional transformative changes, there's a lot that we're trying to juggle on campus. And to be honest, one thing that's kind of extremely nice is we don't have a state law. Early on, I think a lot of people in my chair in states that had a state law were pretty excited about that. And almost all of my friends in those states that now have state laws are regretting it because they're trying to figure out how it's going to work. And I think for us, we've taken a very, very flexible and very freeing approach to name, image, likeness. It's very Purdue in terms of the entrepreneur spirit. I think we're a little unique in that, one of the things that they cited when they talked about the name, image, likeness changes from a legislative standpoint was that there was about 200 some odd waivers over a 6-year time period. We had 15 of those waivers. Now, granted, we had a few student athletes that were 4 or 5 waivers each. Steele Johnson, still, Olympic medalist, he had quite a few. But that's what's fun about being on campus, is you get to interact with coaches and student athletes and find solutions to what they're trying to get done. So as we kind of balanced all that, we've really been tracking on this for about 1.5 years. So I was very busy with COVID, like the rest of my colleagues on campus and whatnot, but I was probably, myself and Peyton Stovall was our assistant AD for student athlete development. We were really digging into an educational and a policy approach to name, image, likeness, knowing that it was going to change, maybe not knowing exactly how, but how could we prepare our students for that? So as we've kind of traversed into that, we're trying to remind them from a practical matter that you've got school, you've got sport, and you've got social. And social, thinking in terms of, it could be social, fun things, eating pizza with friends. It could be social justice. It could be charitable work. It's whatever fuels your soul. And now you have this 4th thing. And so for a number of them, they've chosen not to actually go down that road. They're focused on their school. They're in a difficult major. They're focused on their season. And for the ones that are doing it, we're seeing a lot of it where it fits with their major. They're selling in sales. They already have some entrepreneur spirit to what they're trying to do. If it's through Cranit or if they're graphic design and they want to, make products and sell them. So it's been kind of neat in that sense. The 2 more practical things that there are fears, if you will, or for them are 1, contracts, and 2, taxes. And some of the tax stuff, again, everything we were joking is a prep session for this, but we're glad we're doing this session today, because if we waited any more time, I'm sure everything that we talked about will change. And some of it did change in the time that we talked the last time, which is the Department of Education has actually released some guidance related to financial aid and how to treat, the Alston stuff, and also, what name, image, likeness earnings should look like. And so the simplest quick example would be, if we're collecting that information from an athletic standpoint to try to project plan out educational initiatives. So if our students are doing a lot of, TikTok and Twitter, well, then maybe we need to do different education to cover those topics and less about how to run camps and clinics, for example. If we're collecting that, then it's going to need to get back to our financial aid office, and it's going to be part of their their FAFSA filling out, as part of their estimated family contribution. So even as we start to figure out what things look like, it's starting to evolve constantly. So from an NCAA guidance standpoint, fortunately, the interim guidance was pretty basic, considering everything else is changing. But really what we try to hit home with the students and the coaches is that there's no quid pro quo, so they can't get paid for not doing the work. What's interesting about that, though, is that literally they can get paid for not doing work and just using their name, image, likeness. So it would be kind of hard to break that one, but it's possible. The other one that's probably a little more prevalent and has been talked about more nationally too, as you see different deals being announced by schools or by entities, is it can't be something that's going to entice a student or a prospect to come to your school or to keep a student. Because as Gloria mentioned, with the transfer change, now anybody can transfer and go right away and play right away. So you don't want to have schools involved in making NIL deals to then attract talent or to keep talent. The other one is that there's not contingent specific benefits. So if our quarterback were to have a deal, it can't be $5,000 arrangement, but if he throws 10 touchdowns, then it's 10,000. If he throws 20 touchdowns, it's 20,000. Those kinds of things. From an institutional policy standpoint, we really only suggestively restrict. What I mean by that is there's an institutional values clause that mirrors one of the federal bills, and that was intentional. And as we educated our students, we said, look, this is going to change. We know for a fact it's going to change, and when it changes, we will change it. But it's really just tobacco, alcohol, marijuana, controlled substances, adult entertainment, and casinos and gambling. All of which in all the meetings we've talked to, even on individual basis, student athletes have not been interested in doing. I think they recognize that might be something that you pick up later in your career, but as you're trying to early on and establish who you are as your brand, that's not really something you want to attach yourself to right out of the gate. And I think the other things to kind of highlight that we're trying to struggle through is that institutional involvement piece. How much can we be involved? I mean, obviously, if we can educate, that's great. But going back to that contracts and tax example, I have a law degree, but I'm not really, nor should I be providing them with legal advice. So we're trying to encourage them as part of that education to say, look, if you have contracts, you should secure an attorney. You should seek some legal advice for it. If you're getting paid, you should be making sure that taxes are being withheld and talk with a tax professional. So it's trying to remind them that they can secure professional service providers to help them through those things, which again, in the past, there were some restrictions on, but they can actually set up a marketing or a name, image, likeness agent. And for our elite student athletes, that's been very beneficial. Anything else you want me to touch on, Julie? I think that's pretty much the nuts and bolts of what it's like on campus.
I think I might just add, to set the stage a little bit, the rush for the NCAA deregulation this past summer really was because multiple states had adopted legislation. And to your point, Tom, Indiana was not one of them, was in the minority. And from a conference perspective, we cover a 7-state footprint. Gloria, I'm not sure how many states the West Coast has, but we were tracking all variations of level of restriction versus no regulation. We have 2 states that still have no law. So it was a very interesting place to be in from a conference perspective, trying to have that proverbial level playing field, if you will, while also trying to understand what are the monitoring needs and expectations, as well as the educational needs and expectations for our student athletes to know what's okay, what's not okay. And then to your point, Tom, what do you do once you earn this money through appropriate channels? So certainly, and that's where we still stand today. There is no federal law. The NCAA is still pushing for there to be a federal law. And Tom mentioned there are some bills, but that's nothing is imminent. That seems to be for certain. So we will continue in this place where we have some states with legislation and others with none. All right, at this point, and thank you, Tom, we appreciate that. So we've covered the external forces from the Supreme Court level, a little snippet there of what we've seen congressionally, as well as Gabe mentioned, there have been other federal agencies acting. Gloria noted what's happened from the NCAA's perspective, and then we've heard what's happened at the conference level, as well as the institutional level. We welcome questions in the Q&A, but until we receive any through there, Tom, I'll start with you first. Can you speak a little bit about just where we see this marketplace to go relative to student athlete opportunities. I know when it first began, there were questions of, is this really, these opportunities limited to a finite amount and the truly elite student athlete, or will we see more expansive opportunities, especially with social media and the ability to facilitate deals through some of these vendors, Open Doors and Influencer, that have established their own marketplace for these transactions? Can you speak to a little bit of that, either what you're seeing at Purdue or in the Big Ten, and then how you see that unfolding?
Absolutely. I think for us, we look at it as a couple different kind of buckets. And one would be, with group licensing. And that's something that could benefit. It's passive income. It would set up in a way that maybe it would be, t-shirts that could be customized on an on-demand, setting online. Mom and dad could order and get the name and number for any particular student athlete that signs up for the group license. That's something that could benefit, elite and, just anybody on the team, quite frankly. I think the other thing that really kind of surprised us early on was, when you start to really dig into like social and influencers, a lot of those, those folks that get those jobs, they're not 15,000, 100,000 followers. Yes, there are some of those, and we have a few student athletes, but if you actually look at the numbers, Christy Dosh with Forbes did a really great article about late July when it came out. We shared it with a number of our teams. It's 1,500 is typically the majority, like 50 to 58%-ish for Instagram, Twitter, and TikTok that are influencers. And so it's really more about, do you have something that interests you personally? And how do you connect with that? And how do you connect with the folks around you? So I think what we've started to see is like, we've had 4-figure deals from a number of swimmers and volleyball student athletes that, for some of its product, but then also for compensation to talk about things that they like, whether it be clothes or nutritional products, all those kinds of things. So I expect that as we get further into this, it's like anything else, right? The kids coming in next year as freshmen are going to be so much more savvy than the seniors that are leaving now. And so in 3 years, it's going to look drastically different than it does today. It'll be really interesting to kind of hopping back to the group part to see what opportunities can kind of be formed from that, to see what expands there. I think the interesting thing for the elite kids is going to be what restrictions or protections will companies place on it. If you sign a particular deal and somebody decides to transfer, is your deal local to them? Is that a deal that you don't have? I mean, I think a car dealer should probably be the easiest example of that. But if you're a national brand, maybe you don't care. And then what if you are a starter and they sign a deal and then going into the next year, they're no longer the starter? Does the company have protections? And it'll get very interesting as it relates to that one caveat with the NCAA rule about performance-based piece. So those are some of the kind of bigger picture things we're kind of tracking on to figure out like where's that going to go, where that trend's going to fit.
Yeah, absolutely. Very dynamic. We're going to switch gears a moment. Gabe, at the end of your comments, you teased that you had a teaser there that you have some thoughts relative to the ongoing onslaught of litigation the NCAA is facing. And we've got a question to have you play that out a bit more in terms of what are some of your ideas or thoughts to really set the stage to combat some of the antitrust litigation coming towards the NCAA.
Sure. So I'd say a couple things. And one is actually to pick up where Tom left off on NIL. Not only are we seeing these group deals, but we're starting to see booster collectives where schools are either helping facilitate or just well-known alum are helping facilitate a group of boosters to pay money into a fund that then gets distributed to athletes at that school. But it's not to make t-shirts, it's not to make a video game, it's not to do a jersey like you would think about in a traditional group licensing deal. Depending on the collective, some of it is just have to make a social media post about the collective. And there's some real question, I think, about whether these are legitimate NIL deals or whether these are either pay for play or recruiting inducements. And we're starting to see more and more of that. And part of the challenge is that, as Tom mentioned, and Julie, you mentioned, there are states that do not have NIL laws in them. The states that do not have NIL laws are only restricted by the NCAA's interim policy or whatever the institution comes up with, or the new constitution. But there's not much in there in terms of restrictions, including there's not much guidance about institutional involvement. There's a caution that institutions need to be careful if they're involved because of potential Title IX issues and potential pay for play issues. But we've seen at schools and states that do not have NIL laws, they are pretty clearly facilitating deals for their athletes. And the athletes in many cases don't even know that the deal is happening until they are told by the school that they're now getting X amount of money for this NIL deal. And the more that that happens, and the more I think we go down that path, the more it looks like pay for play, and the more these are recruiting inducements, and the more it looks like these are benefits unrelated to education. And the more the NCAA allows that, the harder it becomes to go back to court and say, we need or have this line that separates college from pro. Because if there are athletes getting paid for name, image, and likeness in name only, but it's really they're being paid to attend the school or to transfer to the school or being paid for their performance, it becomes harder for a judge, much less Justice Kavanaugh, to say, yeah, we want to protect this model. This model is different than pro sports. So what I think, and I think most people agree with this, to answer the question you started with, Julie, there has to be a real shift back to a focus on education and a focus on academics and a focus to that real collegiate model, if that's the model we want to maintain. If it's not, then we're headed on that path to having a semi-pro model, at least in certain sports. So I think through the work that Gloria is doing on the Constitutional Committee, all of those things, trying to put student first instead of athlete first, because that's why the NLRB, that's why federal courts, they look at what the reality is. And they look at the fact that an athlete, if they go to a professor and say, I have to miss class because I'm playing in a game, they say, okay, I'll sign the slip that says you can do that. But if the athlete goes to the coach and says, I have to miss the practice of the game because we have a great field trip for my class, no. And when courts look at that, when legislators look at that, they say, well, I thought this was supposed to be academics first. So I think there has to be a real fundamental shift in the way that we treat college athletics and the way that we distribute revenue. Because if the NCAA does not make that shift on their own, then these external forces are going to keep putting pressure on them and say, look, we deferred to you in the past when it looked like it was college athletics focused on education. It doesn't look like that much anymore. So there's nothing really to defer to. So in order to get protection from the courts, from Congress, from the legislators, from the NLRB, I think there has to be this real movement to get back to education at its core, or the other outcome is to get Congress to step in and pass legislation. And I'm in a hotel room, you might be able to see by the weird lamp and everything, because I was meeting with a US Senator today, talking to him about the possibility of federal legislation. And his answer was, we all want it, but it's not moving anywhere. And that's the problem. You're in a bad spot if you're asking Congress at this day and age to step in and save college sports. So it's looking more and more like it's going to have to come internally to stave off those external threats.
Thank you for that answer, Gloria. I think that's a good segue back to you. In terms of the work of the NCAA, I think we can now talk about the Transformation Committee, the official phase 2, right? Because that's where the transformation is going to have to happen. First of all, I think to your point, Gabe, I'll note the NCAA Constitution that's been presented by the phase 1 group has, as you probably know, the first principle, a true commitment to education first and the full-time pursuit of education by all student athletes across all divisions. That's an association-wide principle. I think the question is, how do you enforce that? How do you uphold that? And you gave some pretty compelling examples that currently are not being followed across the board relative to truly prioritizing the pursuit of education over the pursuit of sport, or even really allowing it to be that co-curricular enterprise. So Gloria, I don't think that one's in the parking lot, but how do you see that taking shape, if that's a fair question, in this phase 2 transformation place?
Yeah, absolutely. I think you hit on the fact that phase 1 Constitution, definitely there's agreement in the room, there's agreement in the membership based on all the surveys to continue with the academic model. And I thought the student athletes were very, very compelling. There's one from each division on the Constitution Committee. And they went so far as to really stand behind and want to retain the label student athlete and be connected to the educational mission. So that's where we are today, at least in what you see in phase 1 of the Constitution. I think one of the other things that prompted the Constitutional Committee was we had a working group in the membership in Division 1 working on name, image, likeness. I don't know how long they've been working on it. Julie, you might know. It was a good year. And they had a full-blown package, very robust, a lot of guardrails, a lot of definition, and a lot of direction to folks like Thomas who are sitting here trying to figure this out on campus. And combined with all the litigation, that whole package got right up to being voted in. And I believe the NCAA decided, we should wait on this because we need to figure out what's happening out there, what's happening with Alston, et cetera, et cetera, et cetera. So what got passed instead of this big package of guidance and definition and guardrails were 2 things. One, to what Gabe said, student athletes should be able to profit off name, image, likeness. And 2, that schools can't pay to play. And that left us in this wild, wild west where schools are trying to figure out, okay, if I can't be involved, how can I ensure that our student athletes aren't getting taken advantage of, aren't signing agreements that are going to make them ineligible? And as Gabe and Thomas both illustrated, we've got all manner of deals out there and all manners of schools that feel that they're really trying to do it right. Or, hey, this is the rule of the day. We're not violating any intent because there's really only 2 guardrails out there. So I think you raise a really interesting question, Julie, is in this phase 2, is that where you then take that big package of work that many put blood, sweat, and tears into around name, image, likeness and feed it into the Division I system? Again, I'm going to be in the room, but I don't know. But that is definitely something I think there's hope out there that we can give folks more guidance and guardrails, because right now it's crazy out there.
Yeah, absolutely. And I think there's some concern clearly of abuses, at least contrary to the spirit and intent of allowing student athletes to capitalize on this as opposed to schools to capitalize through boosters, or I liked Gabe's point of the booster collective. I'm going to use that phrase moving forward. Tom, one of the questions we had in the chat relates to just when you're advising student athletes of the need to get those professional opinions. And it strikes me as ironic because I can share not just 10 years ago, 15 years ago, when I was at the NCAA, agents were not generally a group that you were referring student athletes to. But now clearly the need for professional advice exists in different realms, including NIL. So one of the questions, since we do have multiple practicing attorneys watching, noted what are some of those characteristics or levels of expertise that are important for student athletes to seek out whenever they need that level of advice?
It's a great question. And honestly, it's one of the most difficult. I think one thing we want to keep in mind is we don't want to recommend, right? We don't want to endorse anybody over anybody else. So it's really more about educating them, like, this is something you need to get. We've signed on with an external consulting partner that doesn't provide legal advice, but can hopefully help to give them some additional guidance on what to look for. We do have an attorney through the dean of students that they can also reach out to kind of get some tertiary advice up to the point of like, yes, you should get a lawyer. Here's why you need it. I think that's really one of the last big riddles, because going back to what Gabe was saying with the booster collectives, like there's those versions of the collectives, but there's also this other problem that we're trying to track on, which is sponsors, multimedia rights partners. They want to have student athletes involved in these deals, and they want them to be involved not for recruiting benefits, completely for business benefits, which may or may not be at the student's best interest. I think that's one of the reasons why we really want to see some sort of protections put in place, from a federal level, from NCAA level, to ensure that like they do have an active voice in that. They do have obviously the ability of representation, but if everything's kind of working behind the scenes in the shadows and the deal's just presented to them, they've never really had a chance to negotiate. And we were always taught in our house, it's not what you're worth, it's what you negotiate. So I feel like they should have that opportunity. But it's tough, right? I know I talked to Professor Klein about it last week, even like as a school that does not have a law school, we don't have a legal clinic, like trying to figure out some solutions to that puzzle, right? To connect them. But what we're hoping is that over time, we'll continue to have those connections, and then not necessarily refer back, but have a list of people that have registered with us that we can share with the athletes. And to your point too, Julie, like, for years, it was never a great interaction with agents. It's actually been wonderful, strangely. I mean, because there's no animosity. It's like, well, yeah, you can sign with them. You just can't be for athlete purposes. In some ways, I think they feel kind of nervous because they're kind of on a trial, like with the athlete, if they're not going to make things happen for them. It's like, well, then maybe you won't be my agent when we're done. So in some ways, it's been actually very nice, and they've been very helpful, in terms of trying to get the student to look at all the angles and make sure that they're getting their I's dotted and T's crossed, so to speak.
Yeah, just one quick follow-up on that. I think what's scarier than the agents is because most of the athletes are not going to have agents because these deals are too small. It's just not worth it for the agent. And if you look at one of the deals, the University of Texas is doing the Burnt Ends Club, which gives cash to their tight ends. That there's not enough for an agent to say, I'm going to be involved in that deal to get a percentage of that. So I think the bigger risk, frankly, is the exploitation that the athletes will face from the third parties directly, the ones who are entering into the deals with them without agent representation, who can take advantage of in terms of signing away their name, image, and likeness in perpetuity, that can put onerous demands on them, that could ask them to put things that will hurt their reputation. There's just so many landmines. And as you all know, college sports did a very good job of putting a bubble around college athletes to protect them from these outside forces. It's like that someone pushed the button and the bubble is gone, and now there's a mad rush, and they're allowed to talk directly to the athletes. And it's just such a fundamental paradigm shift that I don't think anyone's quite ready or knows quite how to prepare the athletes or the coaches or the parents or anybody for what's happening.
Completely agree.
And I would just add, Gabe, that example you just gave is interesting. The Burnt Ends, that's still about Texas on the logo. It has nothing to do with the brand value of the individual players in that one. It's still the affiliation with the school. And then secondly, I think we've already seen a couple of examples out there of student athletes losing their brand or their sponsorship or NIL because of maybe a knuckleheaded decision that, young people might make in their college years.
The other thing to stack on top of that is we've started to see a shift even within the collectives, where some of the more recent created ones are not doing let's pull a bunch of money together and give it to them. We're now going to go interact with sponsors and partners. We don't want you to go through, their fields, IMGs, because they hold the rights on that side. So we're going to be that other side of the coin. The pros have been dealing with this setup for decades, and we're adopting it like in the last 5 months. So it's, we thought we were going to get to group licensing, but I honestly thought that was going to be a conversation and a topic that we would really hash out like in April and May after everybody's been through an academic year. And 1 month after, we were trying to figure out what is it, how does it work, what, how can we set it up without being involved? How do we make an opportunity available without locking students in? How do we do this in the most, ethical and legally responsible way? It's happening faster than I think people realized it would, even though we all thought it was going to happen very fast.
Group licensing sounds like a fantastic topic for a future CLE. Along with several other topics raised here today. So I think for all of our participants, just thank you to our esteemed panelists. You all are truly remarkable and appreciate your perspectives and your insights and your input. And even though our issues continue to grow in college sports, the good news is we've got a lot of dedicated folks dedicated to this these opportunities and trying to continue to figure out how to make them work. So Gabe, I'm glad to hear that you're visiting with Senator to try to figure out what might be a framework. That's good news. We, again, I want to just thank all of the participants as well for joining us, and the Cohen family for sponsoring this opportunity, and for McKinney for pivoting to make this virtual. So again, thank you so much. And our panelists, you're welcome to stay on for just a moment, but everyone else, thank you again for joining us, and have a good evening.